I want to go back to restrictive versus accommodating because this is important. The first part of the definition of immigration law is to determine entry into the United States. So it's restrictive immigration law that seeks to limit or deny entry into the United States. Accommodating immigration law seeks to encourage entry to the United States. So not all immigration law is the same. Not every bill is the same. You have to really look at it in order to understand what is the language saying. Is it restricting or is it accommodating? And that's a very, very important point when we look back at the Homestead Act. And then the second part, does it provide the components for naturalization? What requirements does an individual need to fulfill to complete the naturalization process? They need to be in the country for 5 years. They need to be in the state that they plan to be residents of for 2 years. And are those requirements contained within the immigration law? So you have naturalization laws and you have state poor laws that are working together. So you can look at these through a simple matrix. So you have accommodating and restrictive, and does it provide components for naturalization? Yes or no? All the naturalization acts, 1790, 95, 98, and 1802, they all provide for naturalization. They provide the components for naturalization, but they're restrictive. Free white persons, these kinds of ideas. You could be or you could come in as a woman, but you're not going to be a citizen. And then you look at some of those awful things from the 1798, you have to be here for 14 years, these kinds of ideas. So they're all restrictive in some way or another. But the 1802 Act, when we look at it again later on in comparison with the Homestead Act, we'll actually see where the Homestead Act makes it in accommodating.